Absolutely incredible. We now return our focus to our next session, which is titled Arbitration Through the Eyes of the Bench, Practice Pitfalls and Perspectives. Now, this discussion will offer insight from the judiciary on arbitration, practice, and key considerations for practitioners. Please join me in welcoming to the stage our moderator, Advocate Lindi Nkosi-Thomas, SC, AFSA Vice Chair, as well as our panelists, Judge Roland Sutherland, Judge Alti Motiba, Judge Norman Davis, Judge Margie Victor, as well as Sir Clive Freedman. Please give them a hand as they make their way to the stage. Good morning. Yes, you can sit down.
Apologies, we're still getting ourselves mic'd up. Apologies, ladies and gentlemen, we're still getting ourselves mic'd up. We should be ready in a minute. Good morning, ladies, gentlemen, His Excellencies. May I be permitted to please stand on the protocol that has already been established in the interest of time. Welcome to this session. This is a session titled Arbitration Through the Eyes of the Bench, Practice, Pitfalls, and Perspective. This session promises to get members of the judiciary, retired and in active office, to share their war stories, to share with us, practitioners, what the blind spots are, and hopefully assist us in our work as arbitration practitioners to circumvent and indeed avoid those. The hallmarks of arbitration are well known: expeditious resolution of disputes, that's speed, confidentiality, party autonomy, and hence it makes a compelling business case to the business community and other people that participate in the movement. However, those promises are nuanced because absent judicial oversight, dare I say absent a pro-arbitration judiciary, all of that work would be rendered nugatory. It is the courts that give arbitration force. It is indeed the courts that safeguard its integrity. It is the courts that draw a line in the sand and tell us as practitioners, so far, thus far, and no further. Now, ladies and gentlemen, I'm joined by an esteemed panel of, like I said, serving active judges and retired judges. They are here to share their war stories. Their bios are on the website, so I'm not going to spend a lot of time taking through us all through their bios in any detail. But first of all, I have towards my extreme left, retired Deputy Judge President Sutherland, who was heading for a considerable length of time a court dubbed the busiest in South Africa, South Gauteng High Court. I also have towards my right the current acting Deputy JP of the self-same court, the busiest court in the land. To my immediate left, I have with me here Sir Clive Freedman, a retired judge of the High Court of Wales and the UK. He was England and Wales, and he was lead counsel before being elevated to the bench. And I also have, towards my further left, Judge Victor, who is a head of training, we were told, by the program director. She heads up training at AFSA, but she's also retired president of the Special Tribunal, a retired judge of the busiest court in the land, being the South Gauteng High Court. And we also have acting DJP. I'm not suggesting, Judge Davis, that your court is not as busy, but by Pretoria Court, in terms of being busy, I believe that it doesn't come close to Judge Sutherland's court. But I stand
It's not true. It's not true.
corrected, absolutely. I stand
Depends on your
corrected. Now, without further ado, let me invite Sir Clive to share with us insights in regard to, on the international plane, in relation to matters enforcement, what practitioners should bear in mind as they prepare and run their arbitration proceedings. Over to you, Sir Clive.
It is a great privilege to participate in this panel, and I thank you for the opportunity to participate in Johannesburg Arbitration Week. It's very fortunate that the court in which I sat is 8,000 miles away, so you wouldn't know whether I was busy or completely unemployed. It seems the wrong way round to start with enforcement, which is what I'm going to do, and then roll back to arbitration itself, which is what the other speakers are going to do. But it is exactly right. The funders start by examining enforcement. The most sophisticated clients do the same. Otherwise, litigation and arbitration can be just Pyrrhic victories. Without enforcement, it could be a financial disaster of throwing good money after bad. It follows that from the very beginning, the astute claimant will be asking, where and how can any award be enforced? So the good news in international arbitration or international enforcement is that the New York Convention will help. The South African award can be taken abroad. The New York Convention, as you all know, has 170 signatories, states including South Africa and the UK. It also has 32 out of the 44 African countries and still counting. In England, without the need for a judgment in the seat of arbitration, the award can be enforced by a simple procedure. It's a two-tier procedure. First of all, an order nisi, and then in the absence of a successful challenge, a final judgment. Very restricted grounds for objection, mainly jurisdiction, fraud and public policy, and restricted where there's been a waiver in the course of the arbitration. The court's policy is heavily pro-enforcement. The court will be very vigilant to ensure that objections are not dressed up appeals on the merits or the facts or the law. That's for the arbitration. Challengers very rarely succeed, but there can be significant time and expense in resisting the challengers. In some cases, enforcement would be in different countries, in multiple jurisdictions under the New York Convention. In other cases, where there are, especially where there are assets in England and Wales, or where there is a defendant resident in England and Wales, there would be enforcement sought there, especially where there are high net worth individuals who keep their assets carefully concealed in offshore jurisdictions behind complex corporate and trust structures. The worldwide freezing order that is obtainable in England, ancillary to the judgment, would be of value. That could then be taken to the offshore jurisdictions where they may reside or where their nominees may be, and domesticated there to try to get to the assets. In a case with a lot of money at stake, that is very important. I want to tell you about a very recent case of the English Commercial Court called Hulley Enterprises and Russia, decided in March of this year. And that has provided us with an excellent account of how the New York Convention is pro-enforcement and how the English courts are. And it's the UCOS litigation. Some of you will have encountered that. Mr. Khodorkovsky was one of the richest men in Russia after the break-up of the Soviet Union. But he had enemies, and he ended up having his assets expropriated, and he ended up in prison for many years. When he came out, he had arbitration in the Netherlands against Russia. There was a record award of $50 billion in favor of him and his companies. And then Russia sought to resist enforcement. Russia itself declared the award null and void, but the Netherlands, the supervising court, they stuck to it and they enforced the award. The latest installment was in England, and Russia sought to say that Mr. Khodorkovsky had acquired his business by bribery and corruption and had run a corrupt business. But the court rejected all the grounds and made some observations of general application. First, that because the statute says that enforcement shall not be refused except in the following cases, the burden is on the respondent to establish that an exception applies. It is a heavy burden. The court has no discretion and must enforce the awards. The issue is not about whether the underlying subject matter is contrary to public policy, but whether the enforcement of the award would be contrary to public policy. The court will respect the findings of the tribunal about matters relating to domestic public policy. Enforcement can only be refused by reference to international public policy, not national public policy. That is the most egregious matters that would contravene universal standards of morality. Now, serial attendees of the Johannesburg Arbitration Week will remember from an earlier conference discussion of the then recent case of Nigeria against process and industrial developments. And that was a very exceptional case, and it might be thought that that opened considerably in the UK the challenge of fraud and public policy. You may recall it was a case where there had been many red flags at the outset. I will not rehearse them, but a very short arbitration of maybe a couple of days led to an $11 billion award inclusive of interest, $6.6 billion and interest. That comprised more than the combined annual expenditure on health and education in Nigeria. So potentially a matter of very serious repercussions, not just for the state, but for the people. After an 8-week application to set aside, the judge found that there had been false evidence given to conceal bribes in relation to the contract and in the arbitration, and found that legally privileged documents had been retained by the contractor belonging to Nigeria. And so that then led to the matter being set aside and the judge making remarks about the nature of the red flags and the regrettably short examination of the facts and the law. Now, the Nigeria case is likely to lead to more inquiring and curious arbitrators. It could be to sniff out fraud by one party against the other, even if it hadn't been raised. It could even be to sniff out a collusive arbitration where the process is being used to facilitate money laundering. But it's a balancing act, because with interventionism from the arbitrators comes another risk. Imagine a case where fraud is believed to exist, it's not uncovered. It might lead to criticisms of delay and even lack of impartiality of the arbitrators. So there's a balancing act and a challenge. But I suggest to you that however disturbing the Nigeria case is, and despite the fact that the arbitral community will no doubt learn from it, the overall message is still pro-enforcement. The time to take the objections should be in the arbitration. To use the theatre analogy of Lord Justice Lewison, an English Court of Appeal judge, the arbitration is the first and the last day of the play, not a dress rehearsal. Allow me to conclude with some prosaic words of Mr. Justice Bright in the UCOS case. Litigation of this kind is not a moral beauty contest. It has not been the function of this judgment to grade either party for morality nor for beauty. In investor-state disputes, these qualities are not present in abundance. The New York Convention and the Arbitration Act are inherently pro-enforcement. They can be relied on by sinners no less than by saints. It is difficult for any defendant to resist enforcement of a valid New York Convention arbitration award. I thank you for your attention.
Thank you, Sir Clive. And if I may now bring Judge Victor in. We've heard about collusive arbitration and enforcement of the challenges and the nuanced nature of the public policy defense. So how does that play out in South Africa from an international perspective?
Thank you, Madam Chair. And I must say I felt energized by the choir earlier, and I'm also energized by the role that the judiciary in South Africa, and indeed throughout Africa, plays in the arbitration landscape. Let me say this, Sir Clive, that the courts in Africa are well placed to deal with sinners and saints. Let me take you to the year 2009 in our Constitutional Court case of Lafuna, Mapapuli, and Andrews. Justice O'Regan opined on the proper constitutional approach to private arbitration. She said we need to bear in mind that litigation before ordinary courts can be rigid, costly, and time-consuming. She emphasized that arbitration is not inconsistent with our constitutional values to permit parties to seek a quicker and cheaper mechanism for the resolution of disputes. So even well before 2017, when our International Arbitration Act was introduced, as early as 100 years ago, in the case of Brown versus Fisher, it was clear that the courts do not play an intrusive role, but they also do not hide from any untoward instances in the arbitration space. As with other contracts, should the arbitration agreement contain a provision which is contrary to public policy, in the light of the values of the Constitution, and indeed in terms of international values, the arbitration agreement would be null and void to that extent. Now, the yardstick for determining whether a provision is contra bonos mores is clear and crisp. It is the spirit, purport, and the objects of the Bill of Rights. So there we have a framework which is clear. Public policy is always an unruly horse, as the late Professor Anthony Matthews of the University of KZN said. But there we have the framework in which we can interpret public policy. Justice O'Regan in the Lafuna case also referred to the judicial approach to arbitration as being consistent with Section 33 of the United Kingdom Arbitration Act of 1996, which provides that arbitrators have a general duty to act fairly and impartially, giving each party a reasonable opportunity of putting his case and dealing with that of his opponent, and that this general duty of fairness cannot be varied by agreement between the parties. And in similar vein, Article 18 of UNCITRAL model law provides that the parties shall be treated with equality and each party shall be given a full opportunity to present his or her case. So in the case of Lafuna, the Constitution's relevance to the judicial scrutiny of arbitration awards was made very clear. And also it was quite clear from Justice O'Regan's judgment that the extent to which the judiciary may scrutinize arbitration awards. So it's very clear that South Africa, and indeed other parts of Africa, courts in other parts of Africa, have a very clear understanding of the role of arbitration and the implementation of awards. Now, what about the South African judiciary and indeed other judiciaries in Africa enforcing foreign arbitral awards? The foundational framework has been set not only by our constitution, but by the adoption of the model law, and which is a part of the International Arbitration Act for South Africa. Sir Clive, one of your central theses is following the money. You've cautioned us, don't end up with a successful award which amounts to a Pyrrhic victory. And he concluded yesterday at our workshop, at our seminar, that you must have in mind the end result before even embarking on arbitration. Where is the money hidden, you said? Now, South Africa has adopted the model law, and if one looks at Article 9 and 17 of the model law, freezing orders, which is very important when dealing with sophisticated syndicates who may wish to undermine or obtain awards by nefarious means. The South African courts, and indeed all the courts in Africa, countries in Africa which have adopted the model law, it would be an easy task to implement freezing orders. Cross-border trade on our African continent has grown exponentially. There are 72 arbitration centers in Africa. Yes, from Cape to Cairo. And with the rise of cross-border trade, disputes inevitably arise. And it's encouraging to see that 32 countries in Africa have signed the New York Convention. Accordingly, Africa offers many facilities for arbitration cases. So as a retired judge, looking at the arbitration landscape, when I was on the bench and now looking at cases after my retirement, we are very encouraged. We're also looking at, as a retired judge, looking at the work of AFSA. In 2024, AFSA formed the SADC division, which endeavors to transform arbitration in Southern Africa. We heard from our CEO, Andile, that AFSA has been going for 30 years, and in that time, a tremendous amount of experience has been built up. There is also the China-Africa Joint Arbitration Center, KJAC, which is a subsidiary of AFSA. And CAJAC was established under the leadership of the China Law Society to meet the need for credible China-Africa resolution mechanisms because of the growing trade between China and Africa. And I've just heard that our CEO, Attorney Andile Nikani, will be sitting in one of those arbitration courts in China in the near future. So it just shows the close ties that we have and also the respect for the arbitration process internationally. In conclusion, Madam Chair, South Africa is the friendliest arbitration destination with the judiciary fully aligned with the aims and goals of both domestic and international arbitration. There are sophisticated support systems to ensure the smooth running of arbitrations, and this includes the enforcement of arbitral awards. So, Sir Clive, let me repeat that we are well able, not only the South African judiciary, but the judiciary throughout Africa, we're well able to deal with saints and sinners. Thank you, Madam Chair.
Thank you, Judge Victor. May I inquire, am I audible? Can you hear me? Thank you. Thank you so much, Judge Victor. And at this point in time, sticking to the war stories as a theme, the lived experience of our judges, and the complementarity of the arbitration movement and the judiciary, let us now bring in retired Judge Sutherland, DJP, and just DJP, in terms of how do you see the arbitration movement, the practitioners and the judiciary working together to alleviate what seems to be a role that is, I don't want to say unmanageable, but there seems to be more demand than resources allow. Thank you.
Yes, thank you for that. I want to talk about policy, not jurisprudence, and how it is possible to render to the litigating public an effective dispute resolution service. The perspective I bring is of a judge who has spent 15 years in a busy court, 6 of them as the head of that court, battling inadequate infrastructure, antiquated and dysfunctional other resources, and increasingly a body of colleagues on the bench who, under the strain of the burden that they bear, are more and more suffering from chronic fatigue. For anyone who is a professional dispute resolver in South Africa and is also a committed citizen, it is absolutely unavoidable to recognize precisely what strain the courts are under. And so I want to invite you to acknowledge that fact, understand the problem, and embrace the 2 proposals that I want to put forward for radical reform. The first point that needs to be made is that we, the profession, need not try to solve our problems in silos. And the mindset I invite you to embrace is that there is an ecology of dispute resolution, of which the court system is the core, the nucleus, and around that nucleus there is the arbitration process, chiefly served through leading arbitration institutions such as AFSA, and there is mediation, served through many mediation institutions as well. These 3 aspects should not be disaggregated. There is a natural, logical, and functional symbiosis which needs to be understood. In that context, I want to put forward that it is open to the professionals in the arbitration market to alleviate the strain under which our courts suffer. I want you to embrace the idea that the arbitration market be expanded by a legislative amendment to the arbitration statutes, which will enable parties to opt in for a full court appeal, an appeal to 3 judges of a division. This is not to overlay the existing market, where, for the most part, sophisticated actors are happy to live with classic arbitration with no prospect of an appeal. But there is a market waiting to be tapped, which I believe would find it attractive if that degree of oversight by the courts could be added on to the arbitral process. Why is this important? It has been made clear over several years that the courts, and I speak specifically of Gauteng, Pretoria is no less busy than Johannesburg, for the record. We cannot cope with providing hearings for 100% of the trials within a reasonable time. And we shan't be able to do that in the short or the medium term. And nor is the state, however well-wishing it may be, in possession of the resources, both financial and personnel, to alleviate that problem. We can probably deal with 25% of the trials that we need to hear, but of the other 75 that we cannot find place for, we can certainly deal with the 10% of those that go on appeal. So I invite you with unashamed passion to embrace that as a reform which will alleviate the strain on the court system and promote the idea of a broad-based dispute resolution ecology. The arbitration market and the professionals in it constitute a pool of talent which has not been sufficiently tapped by this ecology I propose. I would like us to see, once again, legislative amendments to embrace the idea of appointing experienced practitioners who almost always would have had some arbitration experience as permanent judges on a part-time basis. Neither the proposal that we opt in for appeals nor for part-time judges is an original thought put forward by me. There are precedents for that in almost all of the jurisdictions we care to compare ourselves to. And in this way, if our mindset is to embrace the ecology that I've put forward, we can alleviate the strain on one aspect of that ecology and render unto the litigating public what they are entitled to have, an effective dispute resolution service. So I invite you to become advocates for reforms of that nature. Thank you.
Thank you, Judge Sutherland. But before I invite the next speaker, may I just put this question to you? On the opt-in radical judicial reform that you suggest for a full court opinion, how would that dovetail with finality as a hallmark of arbitration?
Well, the question you raise relates to party autonomy. It does it no prejudice whatsoever. And as I've said, it's not even an original idea. If parties want an appeal, then they shall contract for it. If they don't want an appeal, they will not contract for it. So the idea that in somehow they are compromising what is the essence of the arbitration process, I think is a misguided criticism. And it has been made abroad no less than here. In the South African context, where we have thought it anathema that there should be an appeal from an arbitration, it is a radical idea. But we are out of step with England, the Gulf, Singapore, Australia, New Zealand, and the United States, who in one way or another have opt-ins and on a rare occasion opt-out provisions. Singapore is at this very moment contemplating whether to extend opt-ins to its international arbitration, never mind its domestic. So I implore you, apply your minds to that as a solution to the problem of our inadequacy to provide to the litigating public an effective litigation service.
Thank you. Thank you, retired Deputy Judge President Sutherland. And now turning to the person that's occupying the seat, the successor entitled, as it were, to retired DJP, acting DJP Modiba. The SCA, I'm now turning to party autonomy. If we may turn our attention now to party autonomy with reference to the Kgalagadi matter. So the question really there for you, Judge, is whether are we seeing a judicial messaging of deference to arbitral tribunals? And if so, how therefore do the courts engage with the tension around, on the one hand, finality, and on the other hand, of course, dealing with correcting, as it were, in terms of Section 33, where a tribunal would have overstepped? Thank you.
Thank you, Advocate Nkosi-Thomas, SC. I'm going to move swiftly to deal with the issues you raise. In the Kgalagadi matter, the SCA overturned a High Court decision that allowed litigation to proceed despite a mandatory arbitration clause. It was very emphatic, the court was very emphatic in that matter, that where parties have agreed that disputes shall be arbitrated, courts must respect that choice, even when constitutional rights, such as access to court, are invoked too loosely. So this judgment makes it clear that party autonomy is not advisory, it is binding. And a recurring theme in recent cases is that courts understand their role as guardians of the arbitration process, not as supervisors of arbitral reasoning. The boundary for judicial intervention is accepted at the front door. That is when jurisdiction, existence, and scope of the arbitration agreement is an issue. And at the back door, when recognition and enforcement of awards is sought, courts strongly resist being drawn into the interior of the arbitration. And I must acknowledge the important role that I've seen AFSA play, intervening as amicus to frame cases within these boundaries, to highlight the interplay between normative domestic legal principles and rules of arbitration, particularly rules of international arbitration, to ensure that courts are aware of these boundaries and remain within them when they adjudicate cases. And the key lessons in conclusion that I will part with is that in most arbitration-related litigation, parties succeed or fail based on what happened during the arbitration itself. I think that's in line with what said Clive and Justice Maggie Victor said earlier, highlighting the importance of respecting the role of the arbitral tribunal. Poorly framed mandates, late objections, and forensic shortcuts are really cured by skillful post-award advocacy. Courts value the that arbitration is deliberately chosen, counsel understands its consequences, and parties must live with that choice. And lastly, the arbitration system works best when courts effectively adjudicate arbitration-related litigation. But courts must be rarely needed. So the system should work efficiently to respect the objective of expediency in the resolution of commercial disputes. And when needed, courts are available, they're principled, and increasingly aligned with international best practice.
Thank you, Judge Madiba. Before I invite Judge Davis to talk about a slightly different topic, Judge Madiba, what sort of missteps have you encountered, now that being your war story as a sitting judge, that you would caution us as arbitration practitioners against? Could it be because the quality of our reasoning in the awards leaves much to be desired, or what else is there for us as practitioners to be on the lookout for and potentially address so as to avoid, to make your work easier?
Yeah, on the issue of reasons, courts, this is a recurring complaint in arbitration litigation in South Africa. Much is made of it in review and enforcement proceedings, but our courts have clarified that arbitral reasons must show a rational connection between the issue, evidence, and outcome, but it's not necessary that arbitral reasons elaborate, it's not necessary that arbitral reasons be elaborate or judicial in style. Courts look at whether the arbitrator dealt with the material issues and not whether the court would have reasoned the issues differently.
Thank you. Thank you, Judge Madiba. Judge Davis, you've played a very integral role in the court annexed mediation, which is now the buzzword in South Africa. And this question really goes to complementarity. ADR being complementing, as it were, the judicial system. What has been your experience in embedding mandatory mediation into the system?
Thank you, Madam Moderator, for allowing me to speak about the actual rock star of ADR, and I assume that's why of all the panelists I've been given a handheld microphone. And then just as a matter of protocol, I see in the electronic version it's incorrectly indicated. The printed version is correct. I'm not currently acting as Deputy Judge President, but I am the senior umpire regarding mediation matters. Now, mediation, you all know, is designed to avoid conflict, and I wondered what can I say to adversarial-minded arbitrators that will interest them in mediation. I thought of putting the following proposal. All the subject matter of your arbitrations might be subject to double mediation, not to diminish the finality thereof, but let me explain, and I'll follow on the route the previous panelists have mentioned, and take you on a short geographical journey, having regard to the time, of course, as the last panelist. Hold on to your seats, it'll be a fast journey. We start from global perspective to continental perspective, and we start in Africa, in West Africa, Sub-Saharan Africa. We start with OHADA, the Organization for the Harmonization of Business Law in Africa, where 17 countries have 9 years ago already adopted a uniform act of mediation. And of those countries, those states, many of them have mandatory mediation. Ghana, for example, has a mandatory mediation in the High Court as part of the ADR Act. If we move down from West Africa, Central Africa, Rwanda has mandatory mediation in almost all of its litigation in the High Court. They use what they call the abunzi, which is their local mediators. They are as skilled as in South Africa. You're aware that the Nkosis and Nkosi-Thomas are all natural mediators. Then we move a bit further east. Uganda has diversion rules in their High Court mediation. Kenya has mandated mediation. Last week, the court even enforced not only the mandated mediation, but mandatory mediation in all family law disputes. Getting closer to home, the SADC countries, a number of examples are there. To our northwest, Namibia has mandatory mediation in all its high court litigation, and they publish tables annually indicating the money spent on, saved on litigation, which would otherwise have been spent. They have it calculated, which I must confess, I don't know how it exactly works, but they claim that they can save over 1,000 court litigating days by the implementation of this system, which has been running for some years. In Lesotho, there's also court-annexed mediation. In South Africa, we've battled now for more than a decade to have the mediation bill passed, and it hasn't been passed yet. And the light on the parliamentary horizon of it being passed soon sometimes flickers instead of shining brightly, and it might be some delay. In the Gauteng division, and Madam Chair, Madam Moderator, I have to correct you.
Again. I retract that comment.
Pretoria is, of course, statistically the largest seat of the two seats in the division. We have currently, for example, 16,000 matters pending in which mediation has not been successfully completed, which we have to deal with. But our problem in Gauteng, principally in Pretoria, but also in Johannesburg, was, as Judge Sutherland indicated, a lack of legal resources. Until April last year, we had up to 50, that's 50, matters on the daily civil trial roll. So if you have 50 matters on Monday, and you have to allocate judges as the Deputy Judge President, and you have 50 matters on the Tuesday, and 50 matters on the Wednesday, there are no judges left by the time you even finished calling the roll, let alone the week of 250 judges. So the mandatory mediation directive was implemented, requiring all civil trials who wish to be heard in the court and who still claim that they have a triable issue to first undergo an attempt at a voluntary solution, and then we force them to attempt mediation. It has cleared our trial roll. From a case management perspective, it is largely, hugely successful. Where previously, for a trial date, you had to wait for between 5 and sometimes even longer years to get a trial date. Now, if you have a matter which you have not unsuccessfully mediated, and you come to our court and you ask for a trial date, where there's a defined triable issue, I can give you a judge in 6 months, a court in 6 months' time with the judge. So, from a case management perspective, mediation was successful. We still have, unfortunately, and I must confess, there's a large volume of recalcitrant litigants which result in other enforcement procedures being overburdened. As I mentioned, the 16,000 default judgment, there are 16,000 also pending in the interlocutory court. I won't burden you with that because I have an eye on the time. But we use, say, 5 judges per week in Pretoria, slightly less in Johannesburg, to burden them with 50 interlocutory matters every second day. They complete between the 5 of them, between 400 and 600 matters per week. We do that on a 10-week term. That's 4,000 to 6,000 matters, and by the end of this year, we will have depleted or extinguished the backlog. But there is then the journey I took you now through Africa and to the mediation directive is indicative of a move to mediation. We know that mediation is a voluntary process, but we want the participation thereon, the consideration thereof, to be mandatory. I was heartened by all of the panelists in the first panel who explained the mediation successes in hugely devastating conflict. It can work in devastating conflict, it can work in smaller matters. So getting back to my initial item of trying to pique the interests of adversary or adversity-minded arbitrators, it might be that in multi-tier, in many of your agreements where there's multi-tier resolution processes, that mediation is first attempted before resorting to arbitration. Mediation was attempted unsuccessfully, then you resort to arbitration. If you come to court then, apart from the deferment to the party autonomy, but if there is a review application or an attempt at setting aside the award, where we now currently have mandatory mediation only in trials, the bill will be, as in other jurisdictions, that there might be mandatory mediation requirements even for those applications. So what you have arbitrated and successfully initially mediated, you might have to mediate again. That's a double mediation I wanted to refer to. But in conclusion, Madam Moderator, as a proponent of mediation, one of those proponents who believe that virtually everything, except when you get to instances of fraud and so on, but everything, even conflict between corporations, countries, and the like, can be mediated. I urge mediators, I urge arbitrators in every arbitration or in every conflict situation not to undervalue the importance of mediation as an alternative dispute resolution. Thank you.
Thank you.
Yeah.
Thank you. Thank you, ladies and gentlemen. We've heard from this esteemed panel from Sir Clive about possible collusive arbitrations. We've heard about radical reform that retired Justice Sutherland is proposing. We've now heard about how successful the mid-court annex mediation has become. Judge Modiba has warned us, or cautioned us rather, about things that we should look out for as arbitrators so as to ensure that our arbitral awards, when they get to the court system, just to alleviate the burden of improperly thought through awards. And Judge Victor equally told us about what's happening on the continent, but what emerges and what comes, the thread, the golden thread that runs through all of these presentations is that the judiciary, globally, continentally, and domestically, by and large, is pro-arbitration. Thank you very much. Let us join me, please, as we applause to our esteemed panel.
Yeah, I see that.
Thank you very much.
We're bloody marvelous, we are.
Thank you. One more round of applause to our panel. You were absolutely amazing. The insights on arbitration, highlighting practice pitfalls and perspectives, and we did enjoy and appreciate those war stories as well. Thank you so much. Ladies and gentlemen, if you need a quick leg stretch, we are going to take a very quick tea break. Due to our full program, we are going to be starting again at 12 o'clock. So you can now make your way very quickly to tea. And then, of course, when we return, I would like to ask our panel for our next session to please make sure that you are mic'd up backstage with the AV crew before the start of our next session. We'll be back again at 12 o'clock.